welcome back from lunch. I say I must have done something right because I got the session right after lunch in the very last session of the Law Institute. So, I found that when you're working with a conference, either you've done something good or not so good. But I appreciate, Megan, your welcome. I appreciate what NASPO has done for us in giving us a CLE that's relative to what we do. So when you're at home and you're going to CLEs, usually it's kind of geared towards private practice. Your contracts work is not necessarily the same, and you heard from Keith as to why. Keith and some other folks from NASPO got together 10 years ago, a little over, and came up with the idea for the Law Institute. And because of the Law Institute, I am able to be a much better lawyer for the state of Georgia. Although I don't represent the state of Georgia, that's the AG. So I work for our Central Procurement Organization. As Megan said, before that I was with the Department of Education. And then I started off my career in procurement, like everybody does, accidentally. So I fell into it, and I'm very fortunate that I did with the Georgia Regional Transportation Authority. And I actually served as a procurement officer. So I've served in pretty much every role. Procurement officer, overseeing the procurement shop with the state, one of the largest budgets agencies in the state, and now I work for the entity that is over the central policy and the large procurements. I said it's like getting called up for the majors when you get that opportunity. So I like to say I have the best job in the state of Georgia, and I'm pretty sure I do. So oh, and that's pre-pandemic McCall. This is post-pandemic McCall. She's been through a lot. So we're going to talk about protests today. What is a protest? Why do we have a protest process? And then we're going to talk about what does a typical protest process look like. And then this is why you're all here, right? You came back after lunch for the strategies for avoiding the potential for a protest. So we'll have some constructive discussions as well. I do want to do my little disclaimer, which I think you will find funny. Oh, and one other thing I wanted to say on my thanks. Megan, thank you for your support. Thank you to Felicia. Thank you for your patience, your positivity. It knows no bounds. Wrangling lawyers may be the hardest job in the nation, and you do it just so well. So thank you so much. And I would like to reiterate what Keith and Megan said. Sit at a table with people you don't know. Ask questions about what they're doing well. Use the NASPO network, and just enjoy every minute you're here, because we're lucky to have the opportunity to have continuing legal education in this type of venue where we can talk to each other, learn best practices, and it's a positive environment. And then you'll see me on the NASPO boards, the network boards, because I ask questions too. And I try to answer some if I know them, or I pick up the phone and I call somebody. So, slide 2. Oh. So you've heard us talking about the Model Procurement Code, and it kind of came to me that we kind of jumped ahead. We assume you may know what the Model Procurement Code is. The UCC you learn about in law school. I didn't even learn that procurement was a thing in law school. So the Model Procurement Code, what is it? The American Bar Association Model Procurement Code, so you can find it on their website. Sometimes it's behind a paywall, and I would reach out to Megan to see how I could find it, along with the Model Procurement Regs if we have copies. But I've gotten a copy of it, a physical copy before at the Law Institute, and they've had it back and forth between the paywall before. So if you're interested in it, do a Google search or check in with Megan to see where you can find something like that. Mm-hmm. Excellent. He's going to send a link around so everybody can have a copy. So I'm going to use that like Keith used the UCC. It's going to be kind of our starting place for discussions as to how states differ. So it provides a framework for procurement regulations, the Model Procurement Code, and procedures to ensure fairness, competition, transparency, and government contracting. It's not a legally binding document. It's how your state chose to adopt it. And during the session a few years ago where we were talking about the Model Procurement Code, somebody referred to it as Franken statutes. I like to think that we took the best. So different states adopted in different manners to suit their policies and how they're structured. We all heard how differently we're structured. That the Model Procurement Code allows for that, and you can modify accordingly in the adoption of your statutes. It also has regulations that sit underneath it, so you'll have model procurement regulations to implement the code. So I'm going to talk about what is a protest. So as we were talking about the model procurement regulations, you're going to see these two definitions. One comes from an IGP's Dictionary of Terms. If you haven't found an IGP, they're another government procurement organization, and they keep you're going to hear all the acronyms, and it may get a little scary. That's a good place to look for an acronym, is in their definitions. But basically, you're going to see both of these align. Written objection, so it needs to be in writing. Somebody can't call you and yell protest unless your state allows it. But it's a written objection to a solicitation or an award of a contract. And NIGP's definition says with the intention of receiving a remedial result. What I'll say is that would be inferred from the model procurement regs. I would think that, why else would they be yelling protest except that they then want a remedial result. So what's an appeal? It depends. That's a lawyer's response, right? In some states, you hear appeal, and that's actually a protest. It's an appeal of an agency action. So states, anybody from Maine? Yeah, y'all have appeals. I think there's some other states, maybe Iowa, do y'all have appeals? Okay, yep. By the way, if you hear me yell out a state, and it's referring to some, and I say they do so-and-so, treat me like ChatGPT and check your law. Actually, I would say also, I didn't do my disclaimer, but what I have to say are my own thoughts. They're not the thoughts of the Georgia Department of Administrative Services. And it's not intended to be legal advice. It's to show you where the sources are, like Keith did. Here's some issues, here's some sources. Think about it and figure out how it works in your state. Other folks use appeal as an escalation in the review of initial decision. So some states have a two-step process in their protest. They have the protest decision, and then they have an appeal of the potential appeal of a protest decision. And Georgia's like that, so we have a two-step process. New York, I believe, has a two-step process. So take a look and see, do you have that two-step before any other additional action may be taken? Where can you find the protest parts of the Model Procurement Code? That sits under the Legal and Contractual Remedies, Article 9. So this is the fun time. Megan, do you want to do the honors?
Hello again. So we are going to use poll everywhere. This will come up again in other sessions, so I'm going to sort of walk you through it this first time. You're going to either use your phone, and when they'll make that a little bit bigger so you can scan it. You can scan the QR code, or you can I suggest the text the word NASPO to the number 22333. 22333, NASPO. It'll text you back, and then you'll be in the system, and so then you can select A, B, or C and hit send like a regular text message, and it will show up automatically on our screens. Everybody got it? Okay, good.
Okay, I'm going to call it. 44 states actually have a bid protest procedure prescribed in statute or rule or regulation. So those of you, you saw the volume that answered yes. 17 states authorize or allow for suppliers to appeal a protest decision. And then 33 states responded that they have a statute, rule, regulation that authorizes a supplier to file a lawsuit after the conclusion of the protest and appeal process. And 26 states have statutory, regulatory, and procedural guidance. That 5 states that responded that they have a bid protest bond to formal competition, we'll talk about that in a little bit, and these numbers came from the NASPO 2023 Executive Survey of State Procurement Practices. So thank you, NASPO, for that research. So why do we have a protest process? You know, wouldn't it just be easier to go straight to award? It'd be more efficient, right? That's how they do it in a private business. You go forth and you conquer after you've got your contract signed. You've negotiated terms, and there you go. In the government world, it doesn't work that way. We all know. The reason is for the ability for bidders, offers, and contractors to have confidence in the procedures for soliciting and awarding contracts. This can be assured by allowing an aggrieved person to protest a solicitation, award, or related decision. I like to think this is kind of similar to licensing type actions where they have a due process ability to be heard. And, you know, this is an idea that it's going to come out somewhere. Somebody has taken the money and time to participate, and if they think that's an unfair process for the award, if you don't have a process in place, the verbalization is going to come out somewhere. So we have a protest process to allow for this transparency and discussion to occur. And the states that don't have a protest process, they oftentimes have an informal process. It just there may not be legal ramifications that you can go to court and sue and that type of thing, but they typically will consider protest informally. You'll see that a lot when you start talking to folks, you know, oh, you don't have a protest process? Well, we do, but it's informal. So I just wanted to point that out. So where can I find my protest process? You can find it in your statutes, potentially, your regulations, your policy, and then the solicitation documents. Those are the places I would go to look for my protest process. Each state's protest processes vary, and different entities within the state may have different procedures. For example, your Department of Transportation or your universities may have different procedures than your CPA, Central Procurement Office, if their purview doesn't if they have different purview than you do. So for us in Georgia, for example, our university system has purview over public works, and they have their own protest process relating to public works. Who may participate in the protest process? Well, it depends. You know, that's another lawyer answer, right? Okay. Interested parties, and we're going to talk about what is an interested party. Your central procurement agency may participate in hearing or potentially as the party that's being protested. You may have interveners, you know, those who have a direct economic interest in the procurement, as well as the apparent successful bidder offerer. The Attorney General may participate, and you may have an ALJ that's doing the hearing, or the judiciary potentially, either at the beginning or at the end. They may be reviewing a decision by the entity that heard the protest initially. So you have varying parties that may be coming in. The importance of a protest process. It sets forth the parameters such as standing, the process, what what you require to be included in the protest, what may be protested, the timing of the protest, whether there's a bond. I had a great discussion both at breakfast and at lunch about protest bonds, things you will never hear when you're back at home with your friends who are lawyers that do other things. They'll never say, I had a great discussion about a protest bond. Nobody wants to hear my stories. My friends that are prosecutors are like, and then who reviews the protest appeal and who issues the initial decision? That information will likely be in your process and your procedures. It also provides available remedies. Standing requirements. So who may file a protest? This is the Model Procurement Code. As I said, things vary between states. Any actual or prospective bidder or offerer or contractor is what's provided in the Model Procurement Code, but there are variations of that. As I said, for example, Alabama allows taxpayers to protest. South Carolina allows subcontractors to protest. So you have to look to your state where your variations, if there are any. Typically states mostly mirror the standing requirements. As I said, oftentimes the term interested party or some variations used. The reason is an interested party would be the one that's typically next in line for an award. They're the ones who, if they are sixth in line and they're protesting something that wouldn't have impacted their potential award, they don't have standing to protest. And unless your state allows it. I should caveat that. Okay. The procurement process, again, I was talking about it before, just you need to talk about what may be protested, look at your form requirements, timing, bond, who reviews the protest appeal and issues the initial decision, what other types of things would you see in your process, potentially. It's time to wake up after lunch. Eat the sugar candy in the middle of the table. Anything else that have y'all reviewed that? Yeah, Keith? Is there an automatic stay? Right. That is one aspect. If you're getting a protest and it's, can you go forward to award or not? Typically, procedures will talk about an automatic stay, which may be lifted in the event of XYZ. Or, if you get a protest prior to close of the solicitation, what are your processes? Typically what we require is that the procurement closing date be extended while we hear the protest so that we can do something about it before bid submission, right, and evaluation and such. So what may be protested and what may not, that's in your protest procedures potentially. And this is the part that I thought would be interesting to talk about, material issues. And I'd like to take a quick pause. As legal counsel, we have the ability to work with our procurement officers at the beginning. They may be new to the state. This may be their first protest. And let them know what the expectation is, how the process isn't scary, that we have an opportunity to look at, this allows us a pause, to look at our procurement actions, make sure they're in the best interest of the state, that we haven't made mistakes that would otherwise create a potential contract issue down the way, we may have made an assumption or a calculation that was erroneous. So this allows us that moment in time, because we're all, I think, have the same viewpoint, right? That we want to get the best value, lowest cost item for our customers, and that we want to make sure that's within budget, that we want to make sure that we complied with law, all of those things, and that we followed the process we said we were going to follow. So when you receive a protest, it's an opportunity for you to reflect on things and to make sure that it's a positive action, that we're doing what we said we were going to do. So we have the ability to work then also with our training teams potentially if we see a number of protests that are valid. And we say that's really a wrong result though. We can look at and talk with our training teams about what are we training. Can we produce better training to target this issue? We can work with our policy divisions and look at policies from other states, look at policies that the federal government has, and look at what's in the best interest of the state with regards to procurement. So if that's your role, I know we talked about what's your role earlier. I'm fortunate in Georgia that I have the ability to talk to all of our divisions, ensure communication, and ultimately I think we all want to make sure that we're obtaining the best value for the state and lowest cost. So, and we all work for the taxpayers at the end of the day, right? So, working with your procurement officers and letting them know the expectations. For example, in our procurement procedures, in our protest procedures, we say there's no such thing as a perfect procurement. We just go out and say it. That shouldn't be the expectation of anyone, that there's a perfect procurement, because in my 20 years of procurements, I have not seen a perfect procurement. The question is, was there an issue that's material? So I think talking with our procurement officers, because people will say some harsh things in protest and set standards that aren't necessarily the standard. And so I think working with procurement officers to let them know if we did something wrong, we need to fix it. And this is our opportunity to address it. But at the end of the day, the expectation, because it's their job, their livelihood, they take pride in it. You've got to be able to handle those feelings and work with folks. So anyway, so that was my little side. Did anybody have, everybody's so quiet. Keith, they talk to you. So anyway, what may be protested and what may not. Limited to material issues, typically. So are we violating the term, violating statute, violating the terms of our solicitation? Start there, and then don't make the assumption naturally that because somebody's protesting that we must have done something that is otherwise prohibited. Where was I? As I said, I'm not a litigator. So there's special lawyers out there who can just talk off the top of their head and such. I have great respect for them, but I'm here presenting because it's an important discussion to have. And if I'm, to take a page out of Keith's book, if none of us will present, then we don't really have content. So I do want to encourage you to participate. So this was the part that I really wanted to set home. I've got a case on it. Typically, material issues are only things that can be protested. So Colorado, for example, I took a page out of their statute. I'm going to give them credit for that. In our protest procedures, it says the decision shall be based on, in Colorado's, it says the decision will be based on and limited to a review of the material issues raised by the aggrieved parties concerning the solicitation or award. And they also specify that the presence of multiple non-material issues in a solicitation or award does not constitute a material issue unless the interested party can establish that non-material issues together, those non-material issues together would be prejudice the outcome of the procurement. So what you'll often see is a shotgun protest is what I call it, where you end up with, you did all these things wrong for pages and pages and pages and pages and pages, but none of the issues are material at the end of the day. So just by virtue of having, I've got some nods, yay.
I was thinking too, a lot of what we talk about with protests are, like the big contract awards, but like we have a protest process for solicitation waivers, like things along the way, that might skip the process. So that was, so it might be something that's, the only material thing is whether this is a sole source, and that's generally easy to know, but that's a shorter timeline than, other protests.
Okay. So here's some quotes from some recent federal cases regarding the issue of materiality. And if I write something like, oh, I'm sorry, I have a question. Okay.
Thanks. I know the microphones are annoying, guys, but there are people who have hearing issues and need the mics, and we need the mic recording for further use. So
Totally
I know
fine.
It's annoying, but please use the mics. Thanks.
It's fine. You're talking about defining materiality, so my question might be premature here because I want to hear what you're saying, but I also wanted to just throw a question out to you.
Okay.
So what do you do with the situation where you get a list of exceptions on an RFP and you like respond to them all, and then like maybe something might be material enough where that might affect other bidders? How does that work with your response to exceptions such that you might make a realization that your RFP actually isn't perfect, right? Your procurement isn't perfect right at the beginning. What do you do?
So I think you've got a really interesting question that is worthy of an hour presentation of itself. But are you asking about contract exceptions or specific exceptions to the requirements of the RFP?
Contract exceptions, but also part of the RFP.
Oh.
I'm a microphone phobia, like seriously, so. I'm asking about both actually, because sometimes their exceptions is like, oh, well, we won't do indemnification, like, that you see all the time. But sometimes they're asking about, will this satisfy, will this product answer the RFP, or something that's a little more robust? I've seen both. So now I just got to 3 hours of a lecture, I think.
So let me start off on the first part. On your contract exceptions, it depends on what your RFP and your law say. I've seen Montana did something very interesting that I'm going, are you Montana? Yeah. I'm going to totally steal this idea. So Montana has suppliers submit their proposed contract exceptions during the procurement process. And then they are posted to your board, your procurement board, and you reserve the right to negotiate any of those exceptions with any supplier.
Okay, so that's exactly the issue, though. Is that enough notice for vendors who might have already passed it on? Like, is there a concern here with that kind of method, I guess?
There's some it depends there, but I would say I'm stealing it because I think it's a great idea in that gives, in our protest procedures, and we'll talk about timing in a moment, you have the ability to protest within, ours is 10 days of knowing or should have known, or X date, which is set depending upon what you're protesting, whichever was earlier. They've been given constructive notice of your intent to consider contract exceptions, and it's public, right? So that would be the argument I would stand on, but that would be something that I would consider. I mean, I'm obviously not the person who writes all of the policies. We run it through our, we have a policy group, and there are a lot of people who weigh in. But I think what y'all figured out is a way to ensure fairness. Under our procedures, again, some procedures are a lot more restrictive on contract exceptions. We just happen to be fairly broad, and I thought y'all had an interesting way to go about it. So that's that one. On your RFP, typically it's in the Q&A process that you should get the flesh out of, do you have exceptions to requirements? People are going, and we'll talk about that in a moment, but you have the ability to fix requirements. They're going to talk what's going to happen in the Q&A process, and your role as a lawyer is really important in the Q&A process, because we can read things from different angles, and we can figure out why people are asking certain questions typically, or at least point to potential issues. In the Q&A process, typically they'll ask about a requirement, and that should lead you to look at that requirement a little bit closer. And that's the process where they should be able to take that. They can protest prior to close of the solicitation in most cases on a requirement. If it's after, it's typically too late, right, on timing. So we need to look at that. But in your Q&A process, you may be able to fix a requirement prior to close of the solicitation if you're going to consider that. If you're not going to consider it, that's a protest in and of itself. That's a hard one to carry. It's an overly restrictive requirement maybe, but it's a hard protest to go. Yes.
So how would you, do you have a confidentiality statute? One, the contents of any proposal shall not be disclosed so as to be available to competing offers. Wouldn't those terms and conditions fall under that? Couldn't it fall under that statute, so that way it is a part of the proposal, so you would, disclosing that, even though it may be to the benefit of the state, could potentially violate a statute?
So our statute is written a little bit differently on records. So I would encourage you to talk with your folks about it. But for us, I would make the argument that your contract is not necessarily what was being sought to be protected under those statutes, because I think the argument is that you've got obviously a competitive advantage at that point if you're trying to protect it, and that would create an issue. You're trying to create a competitive advantage with your contract. So I think, talk to your folks, but that would be my argument. Yes.
So we have a similar confidentiality statute in Alaska law, and some of the ways to get around that is, for instance, recently I was advising an agency on a solicitation that resulted in only one bid, and the offered, their proposal, signed the certification, say I'm agreeing to all the terms in the RFP, but then submitted exceptions, which are not allowed for, except for things like indemnity and liability and things like that. And so because the proposals are confidential until the notice of intent to award, we also have a provision where if we only have one proposal, we can cancel the solicitation and rebid. And I just talked to the agency about, well, first of all, it's probably not responsive if they're offering something that's separate from the scope that the agency is asking for. But I talking to the agency, one of the ideas was to, if this is something that they're proposing that seems like it would work better for the agency, then you need to rewrite your scope, put it back out to bid, reopen it up and put it back out and make sure everybody knows that. So you're not disclosing what somebody else offered, but you're asking for what somebody, in a way, has offered before that looks like it would work better for the state, and maybe there are other people then that would open up the process more.
Okay. Thank you for that. Going back to the federal case law, this is 2022. I found a couple of decisions that I thought were very interesting in federal case law. The first one's Ecagra Partners LLC versus the United States, 2022 U.S. Court of Federal Claims. They said, this court does not examine procurement decisions with an electron scanning microscope searching for the slightest of imperfections. As Judge Tapp recently noted, even violations of law, let alone innocuous mistakes, should not result in setting aside awards unless those mistakes have some significance. For any good lawyer can pick lint off of a government procurement. I was like, where have these decisions been in my life? If you see something like that coming out of Georgia Department of Administrative Services, there's a good chance somebody won the lottery and didn't tell people and was going to make their departure that way. No, I thought that was an interesting one. Another one, Hatna Logistics LLC, United States, being the United States, another 2022 U.S. Court of Federal Claims decision. It starts out with the following sentence. So this is the first sentence of the decision. And it describes a multitude of claims submitted in a single protest. This case illustrates that no matter how many variations of pasta are thrown at a wall, sometimes none of it sticks. I know. But see, we can talk about this at the Law Institute, and all of us get the joke. Moreover, a Hatna fails in any event to demonstrate prejudice on the merits, an issue in this court's experience which plaintiffs all too often do not pay sufficient attention, usually at their own peril. That is just literary genius, right? So I think explaining that to our issuing officers takes some of the pressure off. Is the expectation is not that it's a flawless process. It's that we didn't have issues to that level that it's a material issue. So check your law to see whether how material is defined and interpreted. And so let's talk about what may be protested and what may not. Bid irregularities, that can be protested. Evaluation process, that's typically one of the protests that we see most often with RFPs, is folks complaining about the evaluation process. Requirements of the solicitation, are they unduly restrictive? Oftentimes what will happen in an RFQ is somebody will take a cut sheet from a supplier and post it and not know the reason behind each of those requirements and whether they really need it. That's the type of protest we see. And then when you ask, so explain what this does, the issuing officer says, I got it from the end user. That's a tough discussion to have. Failure to follow procedures or compliance with your policy, regulations, or law, that can also bundle up to everything pretty much. Technical errors, spreadsheets that don't calculate correctly. I've seen so many of those. And so now tell folks, check your spreadsheet once, check it twice, now have somebody else check it. So that happens on occasion. Bias or favoritism. There are a lot of allegations. I say a lot. There are allegations because I think that's one of the things that's most striking to your procurement officers is allegations of bias or favoritism because they oftentimes see themselves as trying to do the best job for the state and they take pride in their job. And when somebody says that they're breaking the law and that they have bias towards a specific supplier, it can get personal. So those are hard to prove as well. Depending upon your procurement standards, bias or favoritism is a pretty high bar to prove it, and you have to provide, at least in Georgia's, convincing evidence. So conflicts of interest, again, kind of tie into that. And affirmative determinations of supplier responsibility are often challenged. How many of you, well, you may not know, affirmative determinations of supplier responsibility can be determined in a few different ways. There's a general responsibility determination, typically. Is this somebody that the state wants to do business with? And I think Keith will probably talk about it a little bit more in his responsiveness, because usually you have to end up touching on responsibility at some point. And then there are definitive responsibility requirements which narrow your field potentially, that somebody has X number of years of experience as opposed to somebody has experience in providing nursing services. Somebody has 15 years of experience in providing nursing services. That would be a specific determination. Your general determinations of supplier responsibility, things like, is this somebody that the state wants to do business with that's ethical, that has financial wherewithal, the things that we'd be looking for. Those decisions, at least in the federal world in Georgia, you can't challenge that. So the way that the affirmative determination. Now, if we say this is not somebody who we want to do business with, we need to have a reasonable basis for that, and that can be challenged. But the general determinations of responsibility, that's really a state decision. So you'll see other parties who've participated saying, well, you shouldn't do business with X company because we're better than them, or they've had a history of litigation in X area. So it's there may be other ways that it can be challenged. For example, if you in federal world, I believe, if you didn't do any determination of supplier responsibility, that may be able to be challenged. But look at your law and your statutes to see what determinations of and your policies to see how determinations of supplier responsibility are treated and whether they can be challenged. So what must be included in the protest? When we talk about form, typically you need the name and address of the protester, appropriate identification of the procurement, a state of the reasons for the protest, the relief requested, supporting documents, evidence, exhibits to substantiate. The things that I would look for in your protest process is things that we've seen in Georgia. One, who has to sign your protest? Who has to sign the protest that's being submitted? Who has authority to do so? You might want to include that in your protest procedures. Sometimes protests are submitted by attorneys. If you specify that it has to be the president of the company and the attorney submits, is that okay? What are the parameters? You want somebody to have to provide you with all the information you need to be able to make a decision. So, as a procurement agency. Protest bid bonds, as I said, that was an interesting discussion. So, a handful of states have protest bid bonds. I think, protest bonds, sorry, not bid bonds, protest bonds. So, Hawaii, I think, has one, the ability to have one. I was talking with, I think, Nevada. Y'all do? Thumbs up. Tennessee, South Carolina, I think, has the ability. 15? Okay, good. They vary as to the dollar amount. So basically, in order to submit a protest, a supplier must be willing to pay a certain amount to have their protest heard. And if their protest is sustained, they get their money back. If not, then the state keeps their money. So it's between 0.5% and 25% of the estimated contract value on those states. Or sometimes they have the lowest bid evaluated. Lowest bid, the 0.5%, 25% of the estimated contract value, lowest bid evaluated, or a specific dollar amount based on the value of the contract. Protest filing timelines. Your procurement procedure is going to set forth when a supplier may protest. And to me, if you ask me what the most valuable part of having protest procedures for the agency is to have an idea of when they can continue to do business without fear of having to have a contract canceled. So you have the Model Procurement Code suggests maybe 14 days. Protest shall be submitted within 14 days as such aggrieved party knows or should have known of the facts giving rise thereto. So think about that in context of if you have a protest on a requirement like Montana was talking about, when would it be most effective for the state to be able to fix that problem and look at the problem and fix it if there is a problem prior to close? So 14 days after posting of the bid, I would think would be that time frame. If it was a protest on the evaluation of a bid, when is that most likely to occur? 14 days after the record's release, notice of intent to award. But you have that knows or should have known. A lot of folks have issues proving that, or on the other side, contrary. So there's another way to go about it. Check your law and see what your policies and see what your policies say. State procedures vary. Some talk about the stage of the procurement and set specific timeframes. So if you're protesting the requirements, it must be by 2 days prior to close of the solicitation, for example. Some procedures use that standard, the known or should have known of the facts giving their rise thereto, and some are a hybrid. Georgia, we did a hybrid, and we said it was a knows or should have known, or we have a table, which is based on the stage of the procurement, and we say whichever is earlier. So I think ours is 10 days knew or should have known, or X date, X number of days within like posting of the notice of intent to award for challenging the award of a contract. So take a look at that. Some states involve a two-step process for submission of a protest. So they may have intent to protest you have to submit, and then you have a formal written protest. I think Florida does that. So you at least know that you're getting a protest and not to move on to contract award. But suppliers then have time to review all the records and give you a good complete protest. Timing for issuance of a decision, some states have that in their protest procedures. Sometimes they don't have timeframes for set issuance of a protest decision, such as Georgia. And I say sometimes, most states don't have that. Don't have a time frame that a protest decision has to be issued by. I would think for me, I find it very interesting that the folks that are generally between 7 and 60 calendar days, I don't know how you do it. If you're looking at a fairly complicated protest, potentially with interveners, and you've got to research all the facts, it just seems like it would be a challenging time frame. So I'm interested to talk to y'all about how you make that work. So I think some of those folks are, let's see, who did that? Colorado, I think, is one of those. Mississippi. Colorado, I think, is 7, and Mississippi, let's see. Sorry. 7 working days. Tennessee and Pennsylvania have 60. Virginia, Louisiana, New York, Oklahoma were somewhere in between. It wasn't Mississippi. So, who reviews the protest decision and issues the initial decision? This is the Model Procurement Code again. Going back to them, it's Chief Procurement Officer or the head of the purchasing agency. There, in reality, a wide variation. You have the Chief Procurement Officer potentially, or a hearing officer that's specially appointed, determinations officer, administrative law judge, or potentially an independent board. I want to say Mississippi has that independent board. So what happens after a decision's been issued? Well, potentially you have corrective action. Sometimes that happens before a decision's issued. If a procuring agency sees that the protesting party has a valid point, they may end up going forth and canceling. That's a corrective action. You may have an appeal to that next party if you have appeal procedures in your protest procedures, and you may have litigation if they've exhausted their appeal and administrative remedies. And by the way, what are the protesting parties seeking? They're seeking potentially what? An award of the contract. They're seeking an award of the contract potentially, but reevaluation. They're seeking cancellation of a solicitation and rebid. And the question is also, you brought up they're seeking an award of the contract. Can your procurement officer overturn an award and give it to somebody else? It's something to look at your procurement policies and see. It's an interesting question. Strategies for avoiding a potential protest or appeal. So this is why we're all here, right? We're here 9 minutes left after lunch. Tell folks what you're going to do and then do what you said you were going to do. McCall, Ginsberg. And that's generally the advice I give to folks starting off in procurements is, like we were talking about with Montana, if we told those folks what we were going to do in the in the solicitation, we're going to take their contract exceptions and post them and potentially allow anybody, we may negotiate those with anyone. At least the folks that are involved in the procurement, I would say, we've provided public notice and you had 10, 14 calendar days because we're a know or should have known state, and y'all didn't protest, so we told folks what we're going to do. We set the expectation up, but it relates to all areas of your solicitation. Let the suppliers know what you're going to do, and then do what you said you were going to do. But there's a corollary to that, because in law, all lawyers say it depends. We have the ability to waive immaterial deviations from the solicitation, right? I've found that to be the most challenging area thus far in what I do in working with issuing officers, because they said, we told folks what we're going to do, and we wanted this requirement, and we told them that, and then we told them that we were going to kick them out if they didn't give us this requirement. And I say, but the requirement was for tax form, and that we could have gotten that after the award. Is that is that material? And this part of the procurement manual says you can waive an immaterial deviation, but I found that issuing officers oftentimes don't want that discretion. Like Keith was talking about, they don't want to they like lines, and it makes it a much easier, cleaner, efficient way of doing business. But in our world, I like to say procurement's an art. So sometimes aren't straight lines to it. So I think working with your procurement officer, letting them know this is generally the best course of action and we should do this, but also think about those instances, where are we trying to accomplish here? What's the purpose of what we're doing? And are we frustrating that purpose? So issuing officers can be even more risk adverse than lawyers, and we're a pretty risk adverse group, right? Yeah. So strategies for avoiding a potential protest or appeal. Talk to your CPO, procurement managers about these ideas. And it depends on your role, again, as an attorney and where you are, but training and mentoring, I am very involved in training. We have a boot camp inspired by NASPO's for our new procurement officers that are leading agency procurement officers. I do 4 half days of training for that each year. I train at the Georgia Procurement Conference. We have a big procurement conference in the state. I train whenever anybody asks me, because to me, being proactive is your best opportunity. And typically, you don't have folks coming out of school as grown-up procurement officers. You think about it, they learn from their mistakes. They can learn from my mistakes in the past for sure, and things that I've seen. So training and mentoring, it's important, especially as we have a new generation coming up in procurement. And think about how hard it is to have a procurement officer coming in from college. I just remember when I came in from law school and how overwhelming it was. So fortunately, I had an opportunity for good mentors. Market research, to me, if NASPO has a class on market research, by the way, NASPO Procurement U. This is a wonderful area for us to avoid protest. On your requirements, if they've done sufficient market research to be able to understand what they need, what the market offers, what they may be excluding intentionally, but ensuring they don't unintentionally exclude suppliers. And it helps you with that at the end after evaluation. Oh, we didn't realize it worked that way, because nobody likes that. So market research and getting your procurement shop to really talk about market research. The other thing is sole sources, and I have avoided saying those words during this presentation. Georgia allows protests of sole source procurements. We post them. Market research a lot of times will result in shadow sourcing. It's not my term, I wish it were, where your end user will go out and they'll do their version of market research and pick the best supplier, and we're like, no, but we have a sourcing event for that. But market research in general, just understanding what the market will allow is important. Contract terms and conditions, I always ask, what have other states gotten? Before we draft a contract to go out for bid, there's something called GovWin. NASPO gives us access to GovWin, so I can see other states' contracts. And I'll also Google to see if anybody's done a procurement recently, but I don't want to put in a limitation of liability that's not going to be tolerated by the marketplace. So it's a good idea for us also as attorneys to engage in that market research. Q&A, the unsung hero, as I was saying, lawyers often can identify why a supplier is asking a question. I think being able to participate in that is a huge benefit, but really explaining the importance to your issuing officers of the Q&A process. And then because they need to be aware, if somebody's asking a question likely for a reason, it may be pointing to a faulty spec, for example. Providing enough time both for the suppliers to review and understand the solicitation and to allow for a potential transition. The potential transition time, oftentimes folks will see a protest come from if their current supplier will be able to maintain a contract for a bit longer. You may see a protest that comes about to take that time frame through. If you have done your procurement a year ahead to allow for that transition and for the protest process to work through, you may not. That's a possibility. But suppliers really need time to be able to review and understand the solicitation. So allowing for time for the suppliers, even though the statute says you only have to have it posted for 30 days, you might have a very complicated procurement. So allowing them to understand what the requirements are and ask questions will save you on the other side of things in the protest process. So I was talking about check the math and then have somebody else check the math. Have documentation complete, reviewed, and ready to release. And then debriefing. Who has a debriefing process? Does your state have a debriefing? This is one of those poll anywhere. So some folks think that debriefing creates more protest or could create a stronger protest. Some folks think that it allows for that communication for suppliers to understand why the state acted in a certain manner, because each of us procures in a different way, so their expectations between states may be uniform, but we don't act in that manner. It allows us to explain our actions, our evaluation, those types of things. So it looks like we're almost evenly split. Look at your debriefing procedures and see if you have them. And the next thing is, can a debriefing take place before the conclusion of the protest period? That varies from state to state. Sometimes states say we won't debrief until after close. And some states say it's more advantageous to debrief prior to the end of the protest period so that they may not be submitting a protest. Okay, something to look at because it looks like some, the debriefing process. Look at it, and then there's some articles out there on debriefing as well. NASPO, I think, has some debriefing materials. So the last thing I'm going to talk about is records availability. Consider that in your protest process. When are records available? When is it that, because suppliers need the information in order to inform a protest, looking to see how quickly you can get the records out. There are states that allow for redaction of things like trade secret, for example. I learned this one from South Carolina. Have the supplier submit a redacted proposal so that you can review that while the evaluation activities are going on, for example, so that you have the records ready to release upon the issuance of the notice of intent to award. And then other, you have open records laws, but you also may have different things in your statutes and regulations to provide for specific availability in addition to the open records FOIA statutes. So you were talking about the contract, the solicitation response is not being available until a certain period of time. Your law very well may be specific to that. Georgia's is specific to contents of proposal, but again, I think there might be some creative ways to discuss it with regards to contract exceptions, as to whether that was included or in the intent. So while I'm not going to give legal guidance, but I think it'd be a nice discussion to have at dinner. So that concludes my presentation, and I'm going to be at the roundtables if you have any questions. So thank you all.